Question 326. An easement created by use of property without the permission of the owner is called A. Prescriptive easement, B. Implied easement, C. Involuntary easement, D. Statutory easement. Correct answer is a prescriptive easement. Involuntary easement is not a standard legal term for a type of easement. Easements are generally considered either voluntary, created by agreement, or involuntary, created by law or use. An implied easement is created by law based on the presumed intent of the parties involved in a property transfer. It often arises when a property is divided and a prior use was evident. While statutes can regulate the creation and enforcement of easements, statutory easement isn't a primary classification based on the method of creation. Prescriptive easements are recognized and defined by statutes, but the key is the unauthorized use. Prescriptive easement is created when someone uses another person's property openly, notoriously, continuously, and hostilely, without the owner's permission, for a specific period of time defined by state law. This required use period varies by state, but it typically spans several years. It's similar to adverse possession, but instead of gaining ownership, the user gains the right to use a portion of the property. Question 327. A real estate licensee sells property to a young married couple but later learns they are both 17 years of age. This transaction could be described as A. Valid, B. Void, C. Voidable, D. Unenforceable. Correct answer is A. Valid. According to California Family Code Section 7002, a person under 18 years old is an emancipated minor if they have entered into a valid marriage, whether or not the marriage has been dissolved. Therefore, since the young couple is married, they are considered emancipated minors under California law and have the legal capacity to enter into a real estate transaction. In this case, the transaction would be considered valid. Question 328. Which of these actions can be legally taken by a minor without prior approval of the court? A. Have their real property sold by a guardian. B. Provide a power of attorney sufficient to encumber their real property. C. Obtain real property via inheritance or gift. D. Both A and C. Correct answer is C. Obtain real property via inheritance or gift. Minors are generally not competent to manage or sell real property on their own. In most cases, court approval would be required for a guardian to sell a minor's real property. A power of attorney allows someone to designate another person to act on their behalf. Since minors are not considered legally competent to manage real estate, they typically cannot grant a power of attorney to encumber, put a lien on, their real property. Inheritance and gift laws are designed to allow the transfer of property wealth across generations. While a minor might not be able to manage the property themselves, a guardian can be appointed to oversee its care and ensure it benefits the minor. Question 329. When the title to property is given to the lender as a guarantee against the repayment of a loan, but the borrower keeps physical possession of the property, it is called A. A promissory note, B. A land contract, C. Hypothecation, D. A trust deed. Correct answer is C. Hypothecation. A promissory note is a written promise to repay a loan, but it doesn't involve transferring title to property. A land contract is an agreement to sell real estate in the future, with ownership typically transferring upon full payment. It doesn't necessarily involve using the property as security for a loan. A trust deed is similar to a mortgage, where title is transferred to a trustee as security for the loan. However, in some states, a trust deed might involve the lender taking possession of the property upon default, which isn't the case in hypothecation. Hypothecation is a legal concept where a borrower pledges an asset, like real estate, as collateral for a loan but retains physical possession of the asset. The lender gains a security interest in the property, meaning they can seize and sell it if the borrower defaults on the loan. Question 330. Josh is a board member of two corporations which both make and market motor oil. He does not disclose this dual membership to anyone. If Josh is subsequently sued for breaching his fiduciary duties, the court would likely base its ruling on that antitrust rules are concerned with preventing anti-competitive behavior and monopolies. While Josh's dual role could potentially lead to antitrust concerns, the immediate issue of his failure to disclose and the resulting potential conflict of interest falls squarely under fiduciary duties. The duty of fair dealing generally applies to transactions between the fiduciary and the beneficiary. While Josh's actions might involve unfair dealing, the primary breach stems from his obligation to be loyal and transparent to each corporation he serves. Duty of implied impartiality is not a standard recognized fiduciary duty in corporate law. The core duties are typically loyalty, care, and obedience. While impartiality might be a desirable trait in some situations, the fundamental issue here is the undisclosed conflict of interest, which violates the duty of loyalty. A key fiduciary duty owed by board members to the corporation they serve is the duty of loyalty. This duty requires them to act in the best interests of the corporation and not to place their personal interests or the interests of another entity above the corporation's interests. Failing to disclose a dual membership on the boards of two competing companies directly implicates the duty of loyalty. Josh's position with both corporations creates a potential conflict of interest, as decisions made at one company could benefit or harm the other. His lack of disclosure prevents the boards from assessing and managing this conflict. Therefore, the court will primarily focus on whether Josh breached his duty of loyalty by failing to disclose his dual board membership, which created a clear potential conflict of interest. Question 331. For the purposes of appraisal, the key element of value falls under two categories: value in use and A. Value in land, B. Value index, C. Value in exchange, D. Value added tax. Correct answer is C. Value in exchange. The key element of value, for appraisal purposes, falls under two main categories: value in use and value in exchange. Value in use refers to the specific value a property has for a particular user or in a specific use. It considers the benefits the property provides to its current owner or for a specific business operation. Value in exchange refers to the value of a property in the open market, representing the price it would likely fetch if sold to a typical buyer under normal market conditions. This is the primary focus of most real estate appraisals. Question 332. A lease that a lessee subleases to another party who is the actual user of the property is called an A. Operating lease, B. Assignment, C. Estate for years, D. Novation. Correct answer is A. Operating lease. An assignment is a transfer of the entire leasehold interest by the original tenant to a new tenant. The assignee becomes directly responsible to the landlord. Estate for years refers to a lease with a definite beginning and ending date. While the original lease might be an estate for years, this term doesn't specifically describe the situation of a subleased property with an actual user. Novation is the substitution of a new contract for an old one, or the substitution of a new party for an old one with the agreement of all parties involved. This would typically involve the landlord releasing the original tenant from the lease and creating a new lease with the subtenant, which isn't necessarily the case in a standard sublease. While operating lease has a specific meaning in accounting and equipment leasing, in the context of a lessee subleasing property, it describes the primary lease under which the original tenant, lessee, holds the property and then grants a sublease to a subtenant, the actual user. The original lease is operating, in the sense that it's the active lease from which the sublease originates. Question 333. Which of the following best describes a trust as a form of property ownership? A. Title is held by the trustee on the beneficiary's behalf. B. Title remains with the original owner who releases it to the beneficiary on a certain date. C. Title is entrusted to a beneficiary if the probate court agrees. D. None of the above. Correct answer is A. Title is held by the trustee on the beneficiary's behalf. A trust involves three main parties. 1. Trustor, or settlor, the person who creates the trust and transfers property into it. 2. Trustee, the person or entity who holds legal title to the trust property and manages it according to the terms of the trust document for the benefit of the beneficiary. 3. Beneficiary, the person or entity who benefits from the trust property. The key characteristic of a trust is the separation of legal and equitable title. The trustee holds legal title, meaning they have the formal ownership and the power to manage the assets. However, they must do so for the benefit of the beneficiary, who holds equitable title, meaning they have the right to enjoy the benefits and use of the trust property. Question 334. If a real property title that is encumbered by a trust deed is transferred through a sale, it is necessary to A. Have the grantor provide the delivery of the deed. B. Repay the trust deed balance in full. C. Attain the permission of the lender. D. Real property encumbered by a trust deed cannot be transferred. Correct answer is A. Have the grantor provide the delivery of the deed. The fundamental legal action required for the transfer of real property title, even when the property is encumbered by a trust deed, is the delivery of a valid deed from the grantor, the seller, to the grantee, the buyer. This act signifies the formal conveyance of ownership rights from one party to the other. Without a properly executed and delivered deed, the legal transfer of title does not occur, regardless of any existing liens or agreements. While the presence of a trust deed, a common security instrument for real estate loans, does not prevent the transfer of property ownership, it does introduce complexities that must be addressed during the sale process. The existing loan secured by the trust deed remains a lien on the property, and the buyer will essentially take title subject to this encumbrance. The manner in which this existing loan is handled is a matter of negotiation between the buyer and seller. Options include the seller paying off the loan in full from the sale proceeds, the buyer assuming the existing loan, which often requires lender approval, or the buyer purchasing the property, subject to the existing loan, meaning they acknowledge and take on the responsibility of the debt without formally assuming it. It's important to note that most trust deeds contain a due on sale clause, which grants the lender the option to accelerate the loan and demand full repayment if the property is sold or transferred without their consent. While this clause doesn't legally prevent the title transfer, it can significantly impact the transaction and often necessitates communication and agreement with the lender. Therefore, while the physical act of transferring title hinges on deed delivery, the practicalities of selling encumbered property involve addressing the existing financing through repayment, assumption, or other negotiated arrangements. Question 335. An easement appurtenant exists between two separately owned parcels of property. Bart owns the dominant tenements and Dave owns the servient tenement. If Bart sells his parcel to someone else, then A. Dave, the owner of the servient tenement, automatically assumes the rights of the dominant tenement. B. The new owner of Bart's property assumes the rights of the dominant tenement. C. The easement lapses with the sale of one of the properties. D. None of the above. Correct answer is B. The new owner of Bart's property assumes the rights of the dominant tenement. A servient tenement is a piece of land that is subject to an easement, which is a right or privilege that the owner of one parcel of real property has concerning another parcel of an estate. The owner of the parcel that benefits from the easement is called the dominant estate or dominant tenement, and the parcel that is subject to the easement is called the servient tenement. When Bart sells his property, dominant tenement, the easement appertenant automatically transfers to the new owner. They inherit the rights granted by the easement, such as access or use of Dave's property, servient tenement. If it had instead been an easement in gross belonging to Bart, or personal easement, the benefit would indeed have ended with the sale of Bart's property to a new owner.